Hearing in the appeal, Nuclear Decommissioning Authority and EnergySolutions.
Lord Panic.
My Lords, my Lady, I appear with Joseph Barrett and Rupert Paynes for the appellant. My Lords, Nigel Giffin QC, whose name appears on the written case for the appellant, who represented the appellant at all stages below, is sadly unwell, and we do wish him a speedy recovery. The respondent is represented by John Howell, Andrew Hunter and Ewan West.
Thank you.
The court will have seen that the court's asked to decide preliminary issues of law which arise in a public procurement claim for damages brought against the appellant by the respondent, and it's brought under the Public Contracts Regulations 2006 as amended, which implement EU directives. And there are two preliminary issues of law before your Lordships and your Ladyship. The first is whether an award of damages may only be made under the EU Remedies Directive and under the regulations where the claimant can satisfy the so-called factor-tame conditions for damages liability set out by the Court of Justice, and in particular the factor-tame criterion that a breach must be a sufficiently serious one. The Court of Appeal accepted our submission that the Remedies Directive only requires an award of damages where the factor-tame conditions are met, but the Court of Appeal concluded that damages are not so confined under the regulations. The regulations are broader, and they're allowed to be broader. The directive does not compel a particular solution. It gives a discretion to the member state. That's the first issue. The second issue is whether the disappointed bidder's claim for damages is defeated or reduced if it unreasonably fails to use the provisions of the directive and the regulations which allow it to seek to suspend entry into the challenged contract, so that if its challenge succeeds, it can be awarded the contract. And the Court of Appeal held that neither the directive nor the regulations make an award of damages dependent on whether a claimant has taken reasonable steps or failed to take reasonable steps to use other available remedies. So those are the two preliminary issues of law. The statement of facts and issues sets out, I hope helpfully, the background. The respondent was a member of a consortium that bid unsuccessfully for a major contract for the decommissioning of nuclear sites. The contract was awarded by my clients, the appellant. We're a non-departmental public body established under Section 1 of the Energy Act 2004 with responsibility for 17 nuclear sites in the United Kingdom. The respondent was aggrieved by the manner in which we marked the tenders against the detailed scoring criteria that we had adopted. And they're suing for lost profits, which are said to be over £100 million, and there are other heads of damages claimed. See paragraph 26 of the agreed statement of facts and issues at page 58, and I won't, unless asked to do so, take any time on that. The court will also perhaps have seen, and I should mention, that as well as the lower courts making findings on the preliminary issues of law, they have also made other findings in this dispute. Mr. Justice Fraser has found in favour of the respondent that the appellant did act in breach of the regulations in a variety of respects. His Lordship's judgment is Appendix Part 1B, page 459. and there's a very detailed analysis. His Lordship, Mr. Justice Fraser, has also subsequently found that the breaches are sufficiently serious on the factor-tame test to justify an award of damages. That judgment is Bundle 6, Tab 80. And both of those sets of findings, that we acted in breach of the regulations and that the factor-tame criteria are satisfied, are the subject of pending appeal proceedings. His Lordship refused leave to appeal, and applications for permission to appeal are pending in the Court of Appeal. For completeness, can I also mention that the other member of the unsuccessful consortium, they're called Bechtel Management Company Limited, they've also now begun their own claim against the appellant, and they rely on some of the findings made by Mr. Justice Fraser, and there is a hearing of preliminary issues in their claim, including limitation issues, in July. So that's the background. Before I come to each of these preliminary issues of law, can I identify for the court the relevant legal instruments that the court is being asked to determine in relation to the substantive obligations of my client and other contractors in this context? The obligations are set out in the Public Sector Directive. That's Directive 7, it's Directive 2004/18, which is Bundle 7, Tab 87, and it's page 3126. The details of that are not material to this appeal. They're in the bundle. We can look at them if necessary, but I'm certainly not going to take your lordships, your ladyship, to that material. We're concerned with the remedies provisions. The domestic implementation of the substantive requirements of the Public Sector Directive is in parts 1 through to 8 of the Public Contracts Regulations 2006, as amended in 2009, and that's Volume 1, Tab 2, page 816. But there, your lordships, your ladyship, will not find most of the substantive provisions because, again, they're not relevant to the issues before the court. Again, for completeness, those 2006 regulations have been replaced by the 2015 regulations, but they don't apply in this case because of the date when the procurement commenced. So we're concerned with the 2006 regulations. So that's the substance of the law. In relation to remedies, in EU law, remedies are governed by the Remedies Directive. And can I invite the court, please, to look at Volume 1 of the authorities. It's tab number 7, page 893. This is Directive 89665 as amended by Directive 2007/66. This is the Remedies Directive. I won't at this stage take a long time on it. Can I just identify it for the court? The crucial provisions, Article 1, in the third subparagraph of Article 1.1. Article 1.1, scope and availability of review procedures. The third subparagraph, member states shall take the measures necessary to ensure that as regards contracts falling within the scope of Directive 2004/18, that's the substantive directive, decisions taken by contracting authorities may be reviewed effectively and in particular as rapidly as possible in accordance with the conditions set out in Articles 2 to 2F of this directive on the grounds that such decisions have infringed community law in the field of public procurement or national rules transposing that law. So that's the basic obligation. Over the page, Article 2, Article 2.1 Member States shall ensure that the measures taken concerning the review procedures specified in Article 1 include provision for powers to do three things. A, take at the earliest opportunity by way of interlocutory procedures interim measures with the aim of correcting the alleged infringement or preventing further damage to the interests concerned, including measures to suspend or to ensure the suspension of the procedure for the award of a public contract or the implementation of any decision taken by the contracting authority. B is to set aside or ensure setting aside of decisions taken unlawfully, etc., etc. And C is the award of damages to persons harmed by an infringer. There must be powers to do all three of those. Article 2(3), when a body of first instance independent of the contracting authority reviews a contract award decision, Member States should ensure the contracting authority cannot conclude the contract before the review body has made a decision on the application either for interim measures or for review. The suspension shall end no earlier than the expiry of the standstill period referred to in Article 2A2 and Article 2B4 and 5. And your Lordships will, Ladyship will see that in a moment. There is a standstill procedure period, and prior to the expiry of it, the contract cannot be entered into. So there's an opportunity to seek to have the matter determined before the contract's entered into. 2(5), Member States may provide the body responsible for review procedures may take into account the probable consequences of interim measures for all interests likely to be harmed, as well as the public interest, and may decide not to grant such measures when their negative consequences could exceed their benefits. So it's up to the local courts to decide whether to stay the contract. A decision not to grant interim measures shall not prejudice any other claim of the person seeking such measures. 6, Member States may provide where damages are claimed on the grounds the decision was taken unlawfully, the contested decision must first be set aside by a body having the necessary powers. 2(7), except where provided for in 2D to 2F, the effects, the exercise of the powers referred to in paragraph 1 of this article on a contract concluded subsequent to its award shall be determined by national law. Furthermore, except where decision must be set aside prior to the award of damages, a member state may provide that after the conclusion of a contract, the powers of the body responsible for review procedures shall be limited to awarding damages to any person harmed by an infringement. And we'll see in the domestic regulations that's what's been done after the contract's been entered into. With some exceptions, the only remedy is damages. Article 2A is the standstill period, and the court sees that there must be a standstill period, and Article 2A2, there must be at least 10 calendar days from the contract award decision being communicated to allow the aggrieved contractor, the aggrieved bidder, to seek to bring a domestic complaint. And I don't think I need to read the rest of that. There's more detail in the domestic regulations. I will read any of the other provisions that my friends want me to at this stage. I was simply then going to go to 2F, which are the time limits, the limitation periods, and there's a limitation period of 30 days that's set out for bringing your claim in 2F1 and 2F2. Applications for review, the time limits shall be determined by national law, subject to 2C, and I don't think I need to go back to that. My friends have drawn attention to Article 3, corrective mechanism. The Commission may invoke the procedure provided for in paragraphs 2 to 5 when, prior to a contract being concluded, it considers that a serious infringement of community law in the field of public procurement has been committed during a contract award procedure falling within the scope of the substantive directive. And they've got a point that there it refers to serious infringement. It doesn't in relation to damages, and I'll deal with that when I come to it, but I just draw attention to it at this stage.
Thank you.
So that's the remedies directive. Then we've got the domestic regulations which implement the obligations. They are in the same bundle, volume 1, at tab number 2. Tab number 2 is the public contract regulations, page 816, and this is tab 1, which is the original regulations, as amended by tab 3, which is the 2009 amendments. And tab 2 is the amalgam of those. It's what is applicable in this case. It's not? Oh, it's the earlier one. All right. The tab 2 is the one that we are applying, and it's the original as amended by 2009. And in that, if your court will go to page 817, the court will see Regulation 32, which deals with the contract award procedures. Subject to an irrelevant provision, a contracting authority shall, as soon as possible after the decision has been made, inform the tenderers and the candidates of its decision to award the contract, conclude the framework agreement, and it has to do so by notice in writing. And 2, where it's to be sent to a tenderer, this notice shall include the criteria for the award of the contract and the reasons for the decision. Right. And under subparagraph 2D, at the top of page 818, there must also be a precise statement of either when, in accordance with Regulation 32A, which I'm coming to, the standstill period is expected to end, and if relevant, how the timing of its ending might be affected by any, and if so, what contingencies, and the date before which the contracting authority will not, in conformity with 32A, enter into the contract or conclude the framework agreement. Right. And if we go to 32A, which is on page 821, this is the standstill period. Page 821, where Regulation 32.1 applies, the contracting authority must not enter into the contract or conclude the framework agreement before the end of the standstill period. Subject to 6, which I don't think matters, where the contracting authority sends a notice to all the relevant economic operators by fax or electronic means, the standstill period ends at midnight at the end of the 10th day after the relevant sending date. So there's a 10-day period to invoke this standstill period. If we then turn on to page 823, the court sees Regulation 47A. There's a duty owed to economic operators. There's a duty to comply with the provisions of these regulations with immaterial exceptions and any enforceable EU obligations. At the top of page 824, subparagraph 2, it's an obligation which is a duty owed to an economic operator. Over the page 825, 47C, a breach of this duty is actionable by any economic operator which in consequence suffers or risks suffering loss or damage. Proceedings for that purpose must be started in the High Court, and then one looks at 47D to 47P for the detail. 47D, this regulation limits the time within which proceedings may be started where the proceedings do not seek a declaration of ineffectiveness. Ineffectiveness is defined in 47K. It means really very fundamental errors. Yep. And it's a 30-day period, see 47D2, normal case 47D2, you have a 30-day limitation period. 47E, once you've started your proceedings, you must serve the claim form within 7 days. 47G gives us the consequences of a challenge. Where a claim form is issued, the contracting authority has become aware of the issue of the claim form and the contract has not been entered into, the contracting authority is required to refrain from entering into the contract. This requirement continues until any of the following occurs. Either the court brings the requirement to an end by an interim order under the next provision, 47H, or the proceedings at first instance are determined, discontinued, or otherwise disposed of, and no orders made continuing the requirement. So we can't enter into the contract if proceedings are started. And then 47H, interim orders. In proceedings, the court may, where relevant, make an interim order, and the court can bring an end to this requirement under 47G1. It can restore or modify, it can suspend the procedure, it can suspend the implementation of any decision. And 47H3, if the court considers it would not be appropriate to make an interim order of the kind mentioned in paragraph 2A, in the absence of undertakings or conditions, it may require or impose such undertakings or conditions in relation to the requirement or regulation. Want me to read 2, do you? 2, when deciding whether to make an order under 1A, the court must consider whether, if regulation 47G1 were not applicable, it would be appropriate to make an interim order requiring the contracting authority to refrain from entering into the contract, and only if the court considers it would not be appropriate to make such an interim order, make an order under 1A. That's bringing to an end the requirement. So during the standstill period, we can't enter into the contract unless the court decides that it's not appropriate to continue the standstill procedure. Then 47.1 deals with remedies where the contract has not been entered into.
47I, yeah.
And here, the remedies under provision 2 at the top of 830, in those circumstances, the court may do one or more of the following. It can order the setting aside of the decision or action concerned. It can order the contracting authority to amend any document, or it can award damages to an economic operator which has suffered loss or damage as a consequence. Different, under 47J, is where the contract has been entered into. And of course that may occur because the disappointed bidder does not use the standstill procedure, or because the court under 47H has brought an end to the suspension, perhaps because a cross-undertaking hasn't been given. In those circumstances, after the proceedings are continued and the disappointed bidder wins, 47J, paragraph 2 applies if the court is satisfied a decision or action taken by contracting authority was in breach of the duties and the contract has already been entered into. In those circumstances, the court, A, must, if it is satisfied any of the grounds for ineffectiveness applies, and they are very limited. They're in 47K, matters such as awarding the contract without prior publication of a contract notice, or entering into the contract in breach of the standstill procedure, none of which applies in this case.
Understood.
But if that is established, then the court must make a declaration of ineffectiveness. 47J2B must, where required by 47N, and again, that's in these limited cases of ineffectiveness, impose penalties in accordance with that regulation. It's an unusual provision. It's a civil procedure, but a penalty is imposed. And then 47J2, by contrast to the must in A and B, under C, may award damages to the economic operator which has suffered loss or damage as a consequence of the breach, and D, must not order any other remedies. So there is simply no power in the court, once the contract has been entered into, other than the wholly exceptional cases of ineffectiveness, the court has no power to overturn the contract, and one understands, of course, why that is so. 47K I've dealt with, and I don't think, unless Mr. Howell wants me to, I need to read any of the later provisions in those regulations. So that's the...
Do we have the definition of contracting authority?
Well, we do, but it's in the main directive, if the court wants to go, the provision, Directive 2004-18, if your lordships and ladyship go to volume 7, at tab 87, at page 3126, this is the substantive directive. Volume 7, tab 87, page 3126, and it's Directive 2004-18, and the title...
Sorry, what page?
Page 3126.
Thank you so much.
And the title is on the coordination of procedures for the award of public works contracts, public supply contracts, and public service contracts.
Yep.
And in the recitals on page 3128,
Yep.
at the top of the page, recital 2, the award of contracts concluded in the member states on behalf of the state, regional or local authorities and other bodies governed by public law entities is subject to the respect, etc., etc. And then if you go to Article 1.9, which is on page 3146,
Yep.
at the bottom of page 3146, subparagraph 9, contracting authorities means the state, regional or local authorities, bodies governed by public law, associations formed by one or several of such authorities, or one or several of such bodies governed by public law. And there's a bit more detail, which I don't think matters, but I hope that's sufficient.
Yes, so they are broadly public
Yes, they
bodies.
are. Yeah. Sometimes there's a slight complication, because sometimes a public body can set up
Yes, I understand that.
its
but
own entity in order to perform the contracting function, but they are all within the realm of public law. And this is one of the difficulties in this context on which we will rely, that this is not pure private law. This is an amalgam of public law and private law. It's public bodies which are compelled to follow a statutory scheme of regulations, and the question is, what damages, liabilities do they owe when they get it wrong?
The character of the duty rather than the constitution of the person who owes it.
Well, according to EU law, no. The question is, under domestic law, whether the character of the entity makes a difference, and that I'm going to have to develop in answer to your lordship. But certainly the obligation is an obligation that is imposed essentially on public bodies, not on private bodies. I mean, if you're a private entity, you don't have these obligations. Yeah.
Regulation 3.
Yes. Yeah. Yes, I'm grateful.
Specific definition for the regulation.
Yes, well, the regulation deals with this. I'm grateful. It's volume 3, tab 33.
well, it carries through the same definition.
Yes, I mean, it's 1541. If the court wants to look at it, contracting authorities are set out with more
I see.
precision. There again, they're public bodies.
Yes.
1541, volume 3, tab 33, 1541. I won't read it out, but the court can see who is covered. So it's more specific, but it's also and is also Schedule 1.
Yes. The private bodies covered by paragraph 3
Yes.
are those listed essentially in W, which is the reflection of the TECAL principle.
Yes, it is. It is. It is. So, may I then turn to the factor-tame issue?
Yep.
As I've said, the question is whether the factor-tame criteria have to be satisfied, and that question needs to be considered under both EU law and the domestic regulations. There's no dispute that the Remedies Directive sets out minimum standards
Correct.
to which national law may add, but it is our contention that the regulations, the domestic regulations, transpose into domestic law the obligations imposed by the directive, and they do not provide any gold plating. They don't provide any additional rights or obligations as to remedies, except where they specifically say so. Can I start, therefore, with the position under the remedies directive? And the court will recall, I showed it to the court a few moments ago, Article 2.1c of the remedies directive requires provision for powers to award damages to persons harmed by an infringement. It does not address the criteria. The directive does not address the criteria for the award of damages, but the Court of Justice in Luxembourg did address the point, and it addressed the point in the Speicher case, and that can be found in volume 2 of the authorities at tab number 18. It's page 1298. It's a case about the tenders for a contract to renew some bridges in the Netherlands. And one of the questions that was put to the court can be seen at page 1342 in tab 18.
Yep.
1342, it's paragraph 34.
Right.
In those circumstances, the local court decided to stay proceedings and to refer the following questions to the court for a preliminary ruling. And one of the questions at 1344, under subparagraph 4c, was if that authority is required to pay damages, does community law set criteria for determining and estimating those damages? And if so, what are they? A good question. And the answer to that question begins in the judgment of the court at page 1355, paragraph 85, and the court says this: by its fourth question, part C, the referring court asks, in essence, whether if the awarding authority has to make good the damages arising from an infringement of EU law on the award of public contracts, EU law provides criteria on the basis of which the damage may be determined and estimated. And if so, what are those criteria? Article 2.1c clearly indicates that member states must make provision for the possibility of awarding damages in the case of infringement of EU law on the award of public contracts, but it contains no detailed statement either as to the conditions under which an awarding authority may be held liable or as to the determination of the amount of the damages which it may be ordered to pay. That provision gives concrete expression to the principle of state liability for loss and damage caused to individuals as a result of breaches of EU law for which the state can be held responsible. According to case law developed since the adoption of the Remedies Directive, but which is now consistent, it's a board claim, that principle is inherent in the legal order of the Union. The court has held that individuals harmed have a right to reparation where three conditions are met. The rule of EU law infringed must be intended to confer rights on them, and then the breach of that rule must be sufficiently serious. There must be a direct causal link between the breach and the loss or damage sustained by the individual, and they refer to celebrated cases, in particular Frankovic,
yes,
and Brasserie du Pêcheur and Factortame, which I'll come back to. 88. As matters stand at present, the case law of the court has not yet set out, as regards review of the awards of public contracts, more detailed criteria on the basis of which damage must be determined and estimated. As regards EU legislation, it should be noted that the directive has been largely amended by the later directive adopted after the date of the facts which gave rise to dispute in the present proceedings. However, on that occasion, the legislature refrained from adopting any provisions on that point. In the absence of EU provisions in that area, it is for the legal order of each member state to determine the criteria on the basis of which damage arising from an infringement of EU law and the award of public contracts must be determined and estimated. See Strasbourg, that's the Graz case, provided the principles of equivalence and effectiveness are complied with. And then they tell us what that means. It's apparent from the case law, the detailed procedural rules governing actions for safeguarding individuals' rights must be no less favourable than those governing similar domestic actions, that's equivalence, and must not render practically impossible or excessively difficult the exercise of rights conferred by EU law, that's effectiveness. And then 92, therefore, the answer to the question is that as regards state liability for damage caused to individuals by infringements of EU law for which the state may be held responsible, the individuals harmed have a right to redress when the rule of law which has been infringed is intended to confer rights on them. The breach of the rule is sufficiently serious, and there's a direct causal link between the breach and the loss or damage sustained. In the absence of any provisions of EU law in that area, it's the internal legal order of each member state. Once those conditions have been complied with, to determine the criteria on the basis of which the damage arising from an infringement of EU law and the award of public contracts must be determined and estimated, provided equivalence and effectiveness are complied with. So that's the position. And we say that Speicher is clear and binding authority with respect for the propositions that Article 2.1c, that's the damages provision, is an expression of the principle of state liability or public liability for breaches of EU law. As a matter of EU law, you are not entitled to damages unless, in particular, the breach was sufficiently serious, but national law can go further if it wishes. But as a matter of EU law, you have to satisfy the factor tame criteria.
There's nothing in the Advocate General's.
The Advocate General doesn't add anything of significance to that. He dealt with it at page 1320. And it's paragraph 78. Paragraph 78 at page 1320, insofar as the action, this is Advocate General Cruz Villalon, so far as the action in national proceedings may be based on infringement of European Union law, whether that is established, which is most relevant to this case, the matter solely for the member state in the context of its national law on liability for financial loss. And the footnotes 41, provided that the requirements set out in the settled case law have been fulfilled, that the rule of European law infringed intended to confer rights, breach is sufficiently serious, etc., etc. So he too refers to factors.
But it's of some interest that he thought it sufficiently clear not to require further discussion.
Yes, absolutely. And indeed, that was the view of the Court of Appeal. If the Court would please go to Appendix Part 1 at page 195, in the judgment of Lord Justice Voss speaking for the Court of Appeal, at 195, at the top of the page, his Lordship sets out, and indeed on 194, the relevant paragraphs from Speicher. And he says, his Lordship says at paragraph 62, in my judgment, what those passages make clear is that the Frankovich conditions apply to the infringements of EU law under the Remedies Directive. But those are the minimum conditions applicable. They're subject to the principle of equivalence. And he adds at 65 on page 196, the Court of Justice in Speicher stated clearly that EU law had not yet provided more detailed criteria. It meant criteria beyond Frankovich, but the Frankovich conditions have always been stated to be minimum conditions. It's open to national law to lay down more generous provisions if they wish to do so, etc., etc. And we say that's right. We have no quarrel with that. Of course, national law can go further. But as a matter of EU law, as a matter of the directive, you're not entitled to damages unless you satisfy the factor tame criteria. Just one reference to what the sufficiently serious criterion means. Could we go to volume 1 of the authorities?
Yes.
Tab 13, where the court will find brasserie du pêcheur and factortame of the Court of Justice. And the relevant passage on this second factortame criterion is at page 1142. And at 1142, it's paragraph 51, this is the court speaking. We're told that community law confers a right to reparation where 3 conditions are met and they're set out, second of them being sufficiently serious breach. And that is clarified or explained in paragraph 55 as to the second condition. As regards both community liability under Article 215 and member state liability for breaches of community law, the decisive test for finding that a breach of community law is sufficiently serious is whether the member state or the community institution concerned manifestly and gravely disregarded the limits on its discretion. So it's a tough test in my submission.
That is a test, is it, which is directed to the decision-making process rather than the result?
Are
both relevant?
It's directed to breaches of community law, wouldn't it?
Well, I understand that, but, and I realise that what is meant by serious may primarily be a matter which is not among the preliminary issues.
No.
But some understanding of it may be necessary in order to analyse the principle by which something might have to be sufficiently serious.
Well, the complaint in this case is that we set out a procedure, we stated what the criteria would be, and we didn't follow them. And my submission would be that as a matter of EU law, I say nothing about national law at the moment, as a matter of EU law, the Remedies Directive requires the satisfaction of that test. It has to be shown, and its application obviously poses all sorts of difficulties and disputes, but in principle has to be shown that in breaching the regulations, it wasn't just any old breach, it was sufficiently serious, and that means we manifestly and gravely disregarded the limits on our discretion.
It's explained in the next 2 paragraphs, isn't it? It does, as my lord was suggesting, really look at the character of the breach rather than the consequences.
Yes, I would accept that.
I suppose the character of the breach can bear in mind the likely consequences, because if something is likely to have a big impact, it may require more attention. But,
You've got to have disregarded the limits on the discretion rather than simply have made a mistake.
Yes, precisely so. Precisely so. And that is for. I'm not inviting the court today to do other than accept those principles. Their application, obviously, is a matter for future argument and determination. But that's the principle in my submission. Now, my friends, the respondents contend that the Court of Justice in Speicher was not deciding that the factor-tame criteria apply as a matter of EU law, subject to different criteria in national law. I say, your ladyship will hear, Mr. Howe, but I say their contention is simply inconsistent with what the Court of Justice said in Speicher in the paragraphs to which I have referred. The respondents, rely in particular on an earlier decision of the Court of Justice in Stad, Gras and Straberg, which is volume 2 at tab 21, at page 1476. And the issue in that case in the Court of Justice was whether it is inconsistent with this Remedies Directive for national law to impose a precondition of culpability or fault on the part of the contracting authority before damages may be awarded. And the Court of Justice said that no such criterion, culpability or fault, may be imposed. And one sees this at page 1483 of the judgment. It's paragraph 29, which sets out the questions that had been referred by the local court. And the question 1 was whether Articles 1.1 and 2.1c of the directive or other provisions of it preclude a national rule under which claims for damages for the contracting authority's infringement of community procurement law are subject to the requirement of fault, including where that rule is applied in accordance with the presumption that fault lies with the contracting authority as a body and its reliance on a lack of individual abilities, hence on a lack of personal fault, is excluded. And the court answers that question at 35 and 36. They say it should first be noted the wording of the directive in no way indicates that the infringement of the public procurement legislation liable to give rise to a right of damages in favour of the person harmed should have specific features such as being connected to fault proved or presumed on the part of the contracting authority or not being covered by any ground for exemption from liability. This assessment is supported by the general context and aim of the judicial remedy of damages as provided in the directive. And that is repeated at 45 in the formal answer. In the light of these considerations, the reply is that the directive must be interpreted as precluding national legislation which makes the right to damages for an infringement of public procurement law by the contracting authority conditional on that infringement being culpable, including where the application of that legislation rests on a presumption the contracting authority is at fault, the fact the latter cannot rely on a lack of individual abilities, hence on the defence cannot be held accountable for the alleged infringement. So a criterion of fault or culpability it cannot be applied. We say there's no inconsistency between that case.
Let me just say, this is a different chamber from the Spiker case.
Different what, my lord?
Chamber.
Yes.
It's a different chamber. It's a judgment which is delivered
2 months.
16. It's judgment which is delivered virtually without an Advocate General's opinion, although there was an Advocate General. It's a judgment delivered, unfortunately,
16 days off.
16 days after the Advocate General's opinion in the
Spiker
combattee Spiker case, and it's not referred to, therefore, in the Advocate General's opinion, and it's also not referred to in the court's opinion, a judgment. So it's not a wholly satisfactory position, is it?
It predates Spiker, because in Spiker...
It's before the judgment in Spiker, but it's 16 days after the Advocate General's opinion.
Yeah,
in
oh,
Spiker.
yes.
So it doesn't get into the Advocate General's opinion.
No. And
it doesn't get into the judgment, even though the judgment is later than it.
And in Spiker, the court refers to the decision in Stradgrass.
Does it?
Yes, if the court would go back please, to Spiker, which is volume 2,
helpful.
tab 18, page 1356, paragraph 90, there's a reference to what they call the case of Strabag and others, that is the Stadgrass case, because it's Stadgrass against Straberg.
Oh, I see. Oh, well, that's
So the court in Spiker is well aware of Stadgrass or Straberg. As it refers to it.
Stadt.
Stadt.
Graz.
Not Stad.
Stad.
Stadt.
Stadt. It refers to it. So there's no difficulty about that. But more substantively, we say that there is no inconsistency between the two cases. And there's no inconsistency because the second factor-tame condition, that is, the breach must be sufficiently serious, is not a requirement of culpability or fault. And the Court of Justice itself has so stated in Brasserie, Dupêcheur and Factortame. Can I
In the Stat Gratz case, was the point being made there that you could have a strict liability?
Yes.
So you can have a strict liability of various degrees of gravity, just as you can have a fault-based liability of varying degrees of gravity.
Precisely. And if there were any doubt about this, Brasserie de Pêcheur and Factortame deals with it. It's volume 1, tab 13, and it's page 1047. And the relevant passage in the Court of Justice's judgment is paragraph 75 to 80, page 1145. Letter E on that page 1145, the heading is the possibility of making a reparation conditional on the existence of fault, the third question in the case. By its third question, the local court essentially seeks to establish whether, pursuant to national legislation which it applies, the national court is entitled to make reparation conditional on the existence of fault, whether intentional or negligence, on the part of the organ of the state to which the infringement is attributable. As is clear from the case file, the concept of fault does not have the same content in the various legal systems. It follows from the reply to the preceding question, where breach of community law is attributable to a member state acting in a field in which it has a wide discretion to make legislative choices, a finding of a right to reparation on the basis of community law will be conditional on the breach having been sufficiently serious. That's the point we've just dealt with. So certain objective and subjective factors connected with the concept of fault may well be relevant for the purpose of determining whether or not a given breach of community law is serious. The obligation to make reparation for loss or damage caused to individuals cannot, however, depend on a condition based on any concept of fault going beyond that of a sufficiently serious breach of community law. Imposition of such a supplementary condition would be tantamount to calling in question the right to reparation founded on the community legal order. Accordingly, the reply to the question must be, pursuant to national legislation which applies, reparation of loss or damage cannot be made conditional on fault, intentional or negligent on the part of the organ of the state responsible for the breach, going beyond that of a sufficiently serious breach of community law. So,
Stadtrat simply reasserts that.
yes.
Yeah.
Yes.
What is meant by fault in this context?
Well, Stad
It
Gratz...
can be intentional or negligent, so it appears to mean something that, again, it appears to be directed at a strict liability.
Yes. I mean, there's obviously gradations here, but what the European Court is saying, is clearly saying, repeatedly saying, is that liability under community law, both generally and in the specific context of the Remedies Directive, only applies in relation to damages if the breach is sufficiently serious, which means manifest or grave disregard. But the local law cannot go further and impose some additional criterion that is fault-based. Culpability. That's what it says. And therefore, we respectfully submit, and the only relevance of it for present purposes, is that my friend is seeking to undermine the Speicher judgment by referring to the statement in the Graz case that fault cannot be made the criterion. And I say that takes him nowhere. It doesn't undermine the requirement in the Speicher case as a matter of community law that the breach only sounds in damages if and to the extent that the breach is a sufficiently serious one. We say that there's nothing very surprising as a matter of EU law that the Speicher judgment says what it does. That is, that the Court of Justice equated the conditions of liability in EU law for damages in this context, that is public procurement in relation to the failures by public bodies, with the general requirements of liability in EU law for state bodies for damages. There's nothing very surprising in that at all. The Factortame conditions are a means of securing an appropriate balance in the public interest between, on the one hand, the compensating of parties who are the victims of illegality, the need to encourage public authorities to comply with their obligations, and in this context also the need to encourage entities to bid for public contracts on the one hand, and on the other hand the protection of the public purse from an automatic liability to pay compensation for breaches of EU law that may not be grave breaches. And that's what Brasserie de Pêcheurs and Factortame is recognising, the need for a balance. Indeed, the Court of Justice refers to the need for such a balance in Brasserie de Pêcheurs and Factortame at paragraph 45. I won't go back to it. And we say, as a matter of EU law, there's every reason why the same balance should apply in the context of public procurement, that public authorities, as a matter of EU law, I'll come to domestic law, should not be exposed to automatic damages liability whenever there is a breach of the obligations that are imposed. These duties imposed by the directive apply to a vast range of contracting authorities. They're acting in the public interest, and the obligations which they have are complex in law and in fact. And it's perfectly understandable that EU law does not impose an automatic damages liability whenever they get it wrong. Indeed, the leading authority in domestic law, leading academic authority in domestic law on public procurement, who's Professor Sue Arrowsmith, identifies the problems here. If the court would look, please, briefly at volume 9 of the authorities, it's at tab 114, the law of public and utilities procurement, Professor Sue Arrowsmith, page 3829. This is volume 1 of the third edition, published in 2014. And if the court, please, would go to page 3833, at the top of the page, Professor Arrowsmith, in the third line, refers to a second significant problem of the current EU regime, its complexity. The sheer number and difficulty of the regulatory rules makes the task of national regulators and individual purchasers very difficult. And then at 373, a bit further down the page, she says, finally, but far from insignificant, the current EU regime is characterised overall by a high degree of legal uncertainty. This is amply demonstrated by the extensive discussions on grey areas of law in the present book. With detailed rules in the directives, this is sometimes a result of the difficulty of agreeing on policy when the directives were drafted. This seems to be the case with the scope for amendments, completion of tenders in competitive dialogue, for example. In other cases, uncertainty arises because of poor drafting and or because the complexities of the subject matter were not fully addressed when the rules were drawn up. And she says there are many examples. And over the page 3834 in the first line, she says, however, what these principles require in any given situation is often very hard to predict in advance of judicial rulings, especially in the context of very complex problems where there's room for reasonable differences of opinion between regulators on the appropriate rules. And about 6 lines further down, she adds, of course, some uncertainty is inherent in any regulatory system. However, the degree of uncertainty seems particularly high in the procurement regime. It's particularly problematic in the context of a function that involves many thousands of individuals making judgments on a daily basis that require an individual understanding of the rules. The high degree of complexity and uncertainty means it's very difficult for purchasers acting in good faith to ensure they comply with every detail of the regime on a day-to-day basis. Failure to do so can have significant consequences, creates a serious danger that purchasers become focused on legal compliance rather than achieving the objectives of procurement policy within the legal framework where there's room for debate what the rules require and the decided portion, the expense of a more balanced approach better able to realise those objectives, etc., etc. So this is a highly problematic area. And I respectfully submit it's really not very surprising for all of these reasons that the Court of Justice came to the decision that it did come to in Speicher, that damages are not automatic and that they are enjoyed only where the breach is sufficiently serious, which means a manifest and grave disregard. The respondent says, well, if that's right, then the directive does not provide effective remedies. To which the answer is, well, that's what the Court of Justice said. It was perfectly satisfied that the remedy is an effective one, even though damages flow only where the breach is sufficiently serious. And indeed, the whole point of factor tame and brasserie du pêcheur is that those criteria are sufficient to provide effective remedies. I mentioned that the respondent relies on Article 3.1 of the Remedies Directive. The Court will recall that was the Commission's power to intervene in a procurement in the case of a serious infringement. And the respondent's point is that no such qualification, serious, appears in Article 2.1c in relation to damages. My answer is that there was two answers. It's not a point which concerned the Court of Justice in Speicher's, and rightly so, my second answer, because the Commission's power of intervention is nothing to do with the award of damages. It's a power to intervene as a regulator before the conclusion of the contract. There's also a new point which my friends are taking, new in the sense it wasn't taken below. They say that if we are right and the directive imposes a sufficiently serious criterion, then that would be inconsistent with the EU's obligations under the WTO agreements. And they rely on the government procurement agreement, which the court can find at volume 9, tab 108.
Thank you.
And it's at 3771. It's Article Roman 20, sub-provision 7 at the top of 3771.
Thank you.
Which says that challenge procedures shall provide...
Sorry, which 3771?
3771, my lord.
Right, yep.
At the top of the page, 7,
Yep.
challenge procedures shall provide for, and then is A and B, but my friends point to C, correction of the breach of the agreement or compensation for the loss or damages suffered, which may be limited to costs for tender preparation or protest. And we say, with respect, that's not much of a point because that provision says nothing about the criteria for an award of damages any more than Article 2.1c of the Remedies Directive. And in any event, this damages award is a limited one because it says it may be limited to wasted costs. So it's even less generous in my submission than the Article 2.1c. But your lordships, your ladyship will hear my friend develop that point in due course if he so wishes. We say, with respect, there's nothing in it, and Speicher's applies.
Well, wait a minute. Are you saying on the first point that... I understand the second point. You're saying an awful lot is being hung on a very slender peg, since the damages could be peanuts, limited to peanuts. But on the first point, are you saying that this should be read to some subject to some limitations, such as one gets in brasserie du pêcheur?
Well, I'm saying it doesn't determine
Exclude.
it doesn't determine the criteria by which damages should be assessed in national law. It doesn't say you're entitled to damages however minor the breach may be. It's entirely neutral, and there's no authority that my friends are able to point to in relation to the interpretation of this provision. I say it's an optimistic submission that EU law in Spijkers
Well, it must mean something in international law, and presumably, is it susceptible of litigation before the WTO, under the dispute resolution mechanisms of the
presumably,
WTO? So presumably they would have to decide.
Yes.
I mean, it is rather curious, as you say, that it can be so limited, but they would have to decide whether it can be restricted or is restricted to serious breaches in the brasserie du pêcheur sense. So
But there is no such jurisprudence that anyone has referred to, and in the absence of any such jurisprudence, I respectfully submit it doesn't take the matter very much further, particularly in the light of the second point, that in any event, this is a very limited provision that applies to wasted costs. And
it's a bit of a tail wagging the dog provision, you say, although no doubt the EU has signed up to it, and it does apply between EU countries and third.
it predates.
Yes, what's the dating?
Yeah. I mean, the obligation predates Spijker, as far as I understand it. So clearly, nobody suggested to the Court of Justice that this was something that should prevent the factor-tame criteria applying to remedies under the Remedies Directive. And therefore, I say there's absolutely no basis why this court should decline to apply Spijker as a matter of EU law. My friends also rely on the judgment of Lord Justice Buxton for the Court of Appeal in the Matra Communications case. This is volume 1 of the authorities, tab number 8, at page 903. This is an early decision, 1999, Lord Justice Buxton for the Court of Appeal. The issue in the case was limitation, time limits, in relation to the then domestic regulations, Public Service Contract Regulations 1993. And the court will see that at page 1653 of the law report, it's page 910 of the memory stick, page 910.
Thank you. Yep.
At B, there's the heading, the claims made by Matra, and at E, it's important at this stage, says Lord Justice Buxton, to note that the damages claimed are not what Mr. Vaughan, he was appearing for the claimant, described before the judge, and which, for purposes of identification only, I will continue to refer to as Norbrook damages. That's factor-tame damages. And at the bottom of the page, Norbrook damages are identified, in particular the last three words, the breach must, and over the page, be sufficiently serious. And at B, it's clear that the damages claim in this case is not a Norbrook claim, not only because Mr. Vaughan so said, but also because no attempt is made in the statement of claim to plead, much less to establish the breach on which the claim is based, was sufficiently serious in Norbrook terms. Mm-hmm. And then over the page at 1655, Lord Justice Buxton at B, at 1, says the damages referred to in Article 2.1c of the directive, the Remedies Directive, are not Norbrook damages. As already noted, that is conceded in this case, but the point needs to be underlined. And there's a bit of detail, and he says at D, the right to damages that the member states are obliged by Article 2.1c to create must therefore be, in community terms, sui generis, and must find its origins and limits in the specific provisions of the directive rather than in more general principles of community law. Well, with respect, no. The Court of Justice decides to the contrary in Spijker. And as the court has seen, this court has seen, the contrary was not argued by Mr. Vaughan in that case. So in my respectful submission, that doesn't take the matter any further forward. So I say, on behalf of the appellant, that the Remedies Directive requires an award of damages to the disappointed bidder, the economic operator who is a victim of a breach of the public procurement requires only where the factor-tame conditions are met, but national law may provide more generous provisions. That is the extent of the EU law obligation. The question, then, is whether the domestic regulations do provide something more generous than this country is obliged to provide under the EU regime. And the Court of Appeal said, yes, the regulations are more generous to the claimant. And if the court would go, please, back to Appendix Part 1A to Lord Justice Voss. His Lordship dealt with it at paragraph 67, which starts on page 196. 67, he says at the bottom of that page, in these circumstances, the question resolves itself into analysis of whether the claim for damages is a discretionary one. For the reason the judge gave, I'm sure it's not, at least not in the sense that the appellant contends. There is no requirement in English law for a breach of statutory duty to be shown to be sufficiently serious before damages must be awarded. A breach is a breach. Once a breach is established, the victim of that breach is entitled to be compensated in damages, such as to put the victim in the position he would have been in had there been no breach. The assessment of the quantum has an element of judgment about it, but the exercise upon which the court embarks is governed by well-established legal principles. The second Frankovich condition is a more restrictive condition for liability in damages than prevails in English law, and is therefore displaced by the national rules in the absence of EU rules in this area as to the determination and estimation of appropriate damages. It does not, I think, says his lordship, matter that the government did not intend to gold plate the EU law on public procurement when it introduced the regulations. It did undoubtedly intend that English law principles should be applied to the determination and assessment of damages awarded under the regulations. So that's the view of the Court of Appeal. Now, we make the following submissions in relation to that. First of all, we emphasise the starting point for analysis. And it's only the starting point, but it's important. The starting point is that the domestic regulations, which the Court has seen at Volume 1, Tab 2, were made under the power that was conferred by Section 2.2 of the European Communities Act. We have that, your lordships and ladyship are very familiar with it, Volume 2, Tab 22, 1493. The purpose of the regulations is to make provision for implementing an EU obligation of the United Kingdom and dealing with matters arising out of or related to any such obligation. It is true in this case, I entirely accept, that conferring a more generous right to damages than the Remedies Directive requires would not be ultra vires the 1972 Act. And the reason for that is that the EU obligation allows for more generous remedies than the directive requires. But the fact that the enabling power is concerned with the implementation of a European obligation is an important starting point in the interpretation of what the regulations were intended to achieve. And the Court of Appeal's judgment, if it were upheld, would mean that Regulation 47J, which is the provision dealing with remedies after the contract is entered into, it would mean that Regulation 47J, made under Section 2.2 of the Communities Act, has conferred on economic operators a right to damages that is more generous than the rights conferred by the Remedies Directive, which is being implemented. And that would have major financial consequences for public authorities. And our submission is that if it were the intention of the regulations to have that in effect, they would say so clearly. They would say so in the text of the regulations, and they would also so say in the explanatory material accompanying them. And that approach, we say, is supported by general constitutional principle. The regulations made under Section 2.2 of the Communities Act are subject to limited parliamentary scrutiny. The court, in principle, should be slow to regard them as doing more than implementing the EU obligation of the United Kingdom, unless they clearly so provide, or unless the explanatory material so states. And the court is very familiar with the principle that it stated in relation to secondary legislation in the public law project case, but can I just remind the court of what it's very familiar with? Volume 6, tab 79, public law project case, page 2962, and the relevant passage appears on page 2988. It's paragraph 27 of the judgment of the President for the court. Your Lordship referred to well-known cases, Britnell, Spathholm, McKiernan, and quoted from what Lord Donaldson, Master of the Rolls, said in McKiernan's, quoted with approval. And what he said was this at 2988, letter F: whether subject to the negative or affirmative resolution procedure, subordinate legislation is subject to much briefer, if any, examination by Parliament and cannot be amended. The duty of courts being to give effect to the will of Parliament, it is, in his Lordship's judgment, legitimate to take account of the fact that a delegation to the executive of power to modify primary legislation must be an exceptional course. If there is any doubt about the scope of the power conferred upon the executive, upon whether it's been exercised, it should be resolved by a restrictive approach. I respectfully submit that a similar principle should apply under Section 2.2 of the European Communities Act, that where a European obligation is being implemented, then unless there is a clear statement to the contrary, either in the text or in the explanatory material, the regulations do no more than implement the obligation of the United Kingdom under the relevant directive. Here, we do have explanatory materials, and the explanatory materials do not suggest any intention to do more than implement the obligation of the United Kingdom. Indeed, to the contrary, and the Court of Appeal recognised this, if the court would go back to Lord Justice Voss, it's Appendix Part 1A, and it's pages 182 to 83. And, Lords and my Lady, it's paragraph 17 of his Lordship's judgment.
Thank you.
At the bottom of the page, page 182, penultimate line, Lord Justice Voss says, our attention was drawn to the thrust of the explanatory memorandum to the regulations, to the transposition note, and to a consultation document of April 2009, all of which make it reasonably clear that the government's intention was to do only what was necessary to implement the Remedies Directive without any gold plating, save where such was expressly identified, and we respectfully submit that is correct. Can I show the court briefly the relevant material?
Yeah.
First of all, Volume 1, tab number 4, we have the explanatory note to the 2009 amendment regulations, and it's the second paragraph.
So what was the reference again? Reference?
Sorry, my lord, it's Volume 1,
Yeah.
it's tab 4, it's page 857.
Second paragraph of the explanatory note, yeah.
Yeah, it's the explanatory note, it's the second paragraph, except where otherwise stated below, these regulations, those are the amendment regulations, implement for England, Wales, Northern Ireland, Article 1 of the directive with regard to improving the effectiveness of review procedures concerning the award of public contracts, which amends the principal remedies directives. And when these amendment regulations were laid before Parliament, there's an explanatory memorandum, which is the next tab. It's tab 5, it's page 859.
Yes.
And at page 860, at 4.3, the instrument this memorandum accompanies is the first of two instruments, each of which implements one of the two articles in the new remedies directive that need to be transposed. At 7.1 over the page, at 861, the amendments are needed to implement the legal provisions contained in the new remedies directives. At 10.2 on 866, they say the impact assessment provides a full narrative assessment considering the impacts of each article in the new remedies directive. It concludes there is no option but to implement the directive, as non-implementation would breach our EU legal obligations and trigger legal proceedings by the Commission to rectify the breach. And at 12.1 on 867, the intended outcomes of this instrument are to implement the new remedies directive in national law by the deadline, thereby achieving compliance with our legal obligations as members of the European Union. And over the page at 868, there's the transposition note, and the third paragraph of that says these regulations do what is necessary to implement Article 1 of the directive, including making consequential changes to domestic legislation to ensure its coherence in the area to which it applies. The impact assessment is the next tab, it's tab 6, page 871, and in the middle of page 871, there's a paragraph, what policy options have been considered, please justify any preferred option. Policy options are implement or not implement. The latter would breach the UK's obligations as a member of the EU, would trigger infraction proceedings by the Commission. The UK must therefore implement. And at paragraph 72, which is on page 887, they say, on 887, paragraph 72, BRE guidance. BRE is the Better Regulation Executive. That was the government unit that's now part of the Business, Energy and Industrial Department. BRE guidance encourages systematic assessments of impacts over a suggested £5 million threshold, avoidance of gold plating, and taking a minimalist approach to implementation. OGC, that's the Office of Government Commerce, OGC has adhered to this guidance insofar as is possible within the context of this implementation. The current policy guidance, which is...
was this document before the Court of Appeal then?
The transposition note, yes, it was. That's referred to, I think, in what I just read, wasn't it, from...
Yeah, you refers to gold plating, yeah.
Yes, the impact assessment was before the Court of Appeal, wasn't it? Yes, it was, my lord. We also have the policy guidance, which is at volume 3 of the authorities, and it's tab number 40,
you.
and it's at page 1777. It's a well, it starts at 1775. It's a document, transposition guidance, how to implement European directives effectively. And at 1777, what do the guiding principles, in the middle of the page, what do these guiding principles mean for transposition? 1.3, the guiding principles are aimed at ensuring the UK systematically transposes so that burdens are minimised and UK businesses are not put at a disadvantage relative to their European competitors. The principles state that when transposing EU law, the government will, A, and this is the relevant one, ensure that save in exceptional circumstances, the UK does not go beyond the minimum requirements of the measure which is being transposed. That's the policy aim. And there is
2013
Yes.
is the aim.
Yeah, we don't have the early one, but it's not a novel proposition. It's been government policy for many years that's how we should proceed. The explanatory memorandum, which I showed your Lordship at Volume 1, Tab 5, also referred, we go back to Volume 1, Tab 5, page 864 to 865, it referred to 2 public consultations, and neither of those consultations, I simply assert, my friend will say if I'm wrong in due course, but neither of those consultations suggested any intention to go beyond what the directives strictly require in any relevant respect. And the same is true of the earlier regulations, because this all concerns the 2009 regulations, there's the 2006 regulations, and there's earlier regulations. And in each case, the explanatory notes, as made, said, in relation to remedies, that the object of transposition is to implement the directives and not in any way to add to the obligations of the United Kingdom, obligations of the United Kingdom under the Remedies Directive. In particular, the 2006 regulations, if we go to Volume 3, this is the 2006 regulations.
Yep.
Volume 3, tab 35,
Yep.
page 1660 is the explanatory memorandum,
Yeah.
and that had with it an impact assessment, which is the next tab, tab 36,
Yep.
and in that, at paragraph 2.2, at page 1664, top of the page, the third line of page 1664, the directive has already been adopted at European level, cannot now be changed. Where appropriate, the regulations include some clarification and elaboration of particular provisions in the draft regulations. However, in line with government policy on implementing directives, they avoid unnecessary super equivalence or any super equivalence which risks being at odds with the meaning of the directive. And that was the point I was making. It's been government policy for some time, not to gold plate, to add when implementing obligations under the directive. My friend's written case says, well, the regulations are unambiguous and therefore the explanatory materials are simply irrelevant. We respectfully disagree. The court will recall that the relevant provision of the regulations is at Volume 1, tab 2, page 830, and it was regulation 47J, remedies where the contract has been entered into, and it's 47J 2C, the court may award damages to an economic operator which has suffered loss or damage. And our submission is that that phrase, may award damages to an economic operator which has suffered loss or damage, is perfectly capable of interpretation to ensure consistency with the EU law obligation which is being implemented, which is that there is a right to damages. The court should only exercise that power in circumstances where the second factor-tame criterion is satisfied. And it is open to the court, of course, to look at the explanatory material in order to interpret the regulation which is designed to implement the obligations of the United Kingdom. There is a lot of authority on the question of whether or not explanatory material may be looked at. There's one judgment of Lord Hope for this court at volume 5, at tab 67, which is page 2617.
Thank you.
In the TUPE context. And in that, the claimants were employed, looking at the headnote 2617, the claimants were employed by a local authority, its leisure department, with terms of employment in accordance with collective agreement negotiated by the NJC. Following a transfer of the department to a company in the private sector, the claimants continued to receive pay increases under the collective agreement in accordance with TUPE. The company was then acquired by the respondent employers when a new collective agreement with revised rates of pay took effect, to which the employers were not party. They considered it not to be binding on them. The claimants brought claims in the tribunal for unauthorised deductions of pay, and they argued that the regulation required a dynamic interpretation requiring a transferee to honour terms and conditions agreed in the collective bargaining process to which it did not belong after the date of the transfer. And if your ladyship go please to page 2628, at paragraph 27, Lord Hope, speaking for the court, said there's no doubt in some respects TUPE was more generous to employees than the directive. And at 28, it's not possible, however, to detect anything in the regulations that is so obviously more generous than what is to be found in Article 3.1 of the directive. Regulation does say something that Article 3.1 does not say in so many words, and he sets that out. And at the bottom of the page, 2628, he refers to various authorities, and he says in the third line from the bottom, no reference to these authorities was made in the public consultation document issued by the DTI, and none of the questions that were asked were addressed to this point, and he refers to that. So he's taking account of the public consultation documents in interpreting what the regulations mean. In relation to explanatory material, it's another judgment of Lord Hope, which is tab 59 of the same volume. The Queen against Montilla. This is not a European court case, but he's looking at explanatory material. And at page 2448, paragraph 35, Lord Hope, speaking for the court, says there's a further point that can be made in Pickstone, which of course was an EU law case, a celebrated case about equal pay for work of equal value. Yep. Lord Oliver said that the explanatory note attached to a statutory instrument, although it was not, of course, part of the instrument, could be used to identify the mischief which it was attempting to remedy. And his lordship refers to authorities. Lord Staines said that insofar as the explanatory notes that since 1999 have accompanied a bill on its introduction, they are updated during the parliamentary process, cast light on the objective setting or contextual scene of the statute and the mischief at which it is aimed. Such materials are always admissible aids to construction. It's become common practice for their lordships to ask to be shown the explanatory notes when issues are raised about the meaning of words used in an enactment. And we rely upon that principle. There's nothing here that suggests any intention to do more than implement the obligations in the directive. It's true that the regulations have been amended from time to time, but at no stage has there been any suggestion of any intention to go further than the directives require in any relevant respect. Again, my friends rely on the 1993 case of Matra Communications, where the Court of Appeal suggested that the intention was to create a private law liability for breach of statutory duty. But as I've indicated to your lordships, that was long before Speicher, and the analysis I therefore submit is of no value. There's another case that I should mention in relation to the 2006 regulations. It's in Volume 1, Tab 11, Risk Management and Rent. It's a case where my Lord Sumption was for the successful local authorities, and my friend Mr. Howell was on the other side, and it concerned the substantive provisions of the 2006 regulations, not the remedies provisions.
Right.
And it concerned what my Lord mentioned before, the so-called Tekal exception, named after a judgment of the Court of Justice, the situation in which a contracting authority enters into a contract with a body that's under its own control, but which it has chosen to establish as a distinct legal entity. And on the terms of the Public Sector Directive as it then stood, it appeared that an authority was bound to undertake a competitive procurement before concluding a contract with such an entity. But the Court of Justice in Tekal said that providing certain conditions were met, the conclusion of a contract with such an entity fell outside the scope of the directive.
Yep.
And this case, risk management, concerned the successful attempt of the public bodies to rely on this Tekal exception, and the claimant was disputing, amongst other matters, whether the 2006 regulations, properly construed, allowed for such an exception. And despite the absence of any explicit provision, the court held that the regulations should be construed so that their scope was no broader than the directive. And Lord Hope, paragraph 24, again referred to the explanatory memorandum. Paragraph 24, his lordship said, it's page 974.
Yep.
It's true that Section 2.2 of the Communities Act is in wide terms. It does not confine any measures made under it to doing the minimum necessary to give effect to a directive. But if it's to be within the powers of the subsection, the measure has to arise out of or be related to an EU obligation. The primary objective of any secondary legislation under Section 2.2 must be to bring into force laws which, under the treaties, the United Kingdom has agreed to make part of its laws. There is nothing in the explanatory memorandum to the regulations laid before Parliament to indicate that it was intended to depart from the jurisprudence of the court as to the scope of the directive. The memorandum says that change to the legislation was necessary to implement the new directive, clarified and modernised the previous text. If the TECAL exception were to be held not to apply, it could only be because the purpose of the regulations was to apply the public procurement rules to relationships that fell outside the regime provided for by the directive. That would not be consistent with the memorandum. It would not be a permitted use of the power. I recognise that is an easier case because the argument that Mr. Howe was advancing was that the domestic regulations should be construed in a way that was inconsistent with the directive. And I have accepted in this case that my friend's approach to the regulation is allowed by the directive. So I recognise that, but I do say nevertheless...
Well, it wasn't inconsistent with the directive. It was inconsistent with the gloss that had been put on the directive by the ECJ.
Yes, which in my respect...
Which wasn't a matter of interpretation of the language. It was essentially something that they laid over the scheme in order to give effect to its economic purpose.
Yes. The ECJ interpreted the directive to allow for this exception. And my friend's argument was that the domestic regulation should be construed in a way that would not allow that exception, even though the ECJ said that it should be applied to the directive. And that's not my case here. My case here is I accept the directive does allow for a broader approach in domestic law, but nevertheless I rely on Lord Hope's recognition that in interpreting the domestic regulations in the public procurement context, it's true there the substance rather than remedies, but
You have to look at it against paragraph 22, where the point that Mr. Sampson, as he then was making about
22, his lordship said he didn't find the arguments of Mr. Howe persuasive. It's sufficient answers Mr. Sampson submitted to say that the basis for implying the TECAL exemption into the regulations to be found in their underlying purpose, which was to give effect to the directive. The absence of any reference to the exemption in regulations is of no more significance than the absence of any reference to it in the directive that was being transposed. The exemption in favour of contracts which satisfy its conditions was read into the directive by the Court of Justice in TECAL. Was thought to be undesirable for contracts of that kind to be opened up for public procurement. Not just a technicality, it was a considered policy of EU law. It would be odd if a significant policy-based exception would apply in some member states, but not others, especially as one of the aims of the directive was to harmonise procedures, etc., etc. Well, yes, I rely on that. Save that, I have to accept that EU law does allow member states in this context to go further. But I do say that just as the Court of Justice was perfectly capable of interpreting the remedies directive so as to impose the factor tame criteria, so this court is perfectly capable of interpreting the regulations, which as to damages are in very similar forms, so as to impose the factor tame criteria in a context where there is absolutely nothing to suggest that it was the intention of the regulations to do more than implement domestically the EU obligation. And indeed, where the explanatory materials make it very clear indeed that the regulations were intended to do precisely that, that is to implement our obligations under EU law and no more. And when nobody was told in explanatory materials, in consultation documents at any time that it was the intention to do more than impose obligations that are imposed under EU law. A further point that I want to raise is the point that I made in partial answer to my Lord Carnworth earlier this morning, that all of this arises in a context that has a large public law element. The obligation is on a public body, admittedly in a context where it is contracting, but they are obligations imposed on public bodies. And as a matter of domestic law, it is well established that a public body is not normally liable in damages for a public law error causing foreseeable loss. Ultra vires conduct does not sound in damages. It's necessary to show there's a tort, misfeasance in public office, or that a statute intended to confer a right to damages. If the court needs it, we have De Smith, which sets out the principles at volume 9, tab 112, page 3823. It's paragraph 19-025. And I respectfully submit that just as the Court of Justice said that the remedies directive must be interpreted as to damages analogously to state liability for damages in EU law, the court should infer, absent anything to the contrary, that these regulations are intended to deal with state liability or public liability for damages and should apply similar principles. That is, that damages do not automatically follow. Now, Lord Justice Voss's answer to all of this, and it's the answer that my friends give in their written case, is that this is a cause of action for breach of statutory duty. And I've shown your lordship, your lordships and your ladyship, the passages in the materials of breach of statutory duty. My answer is that the fact that the liability is for a breach of statutory duty does not answer the question as to the principles to be applied in relation to the award of damages in a context where the regulations are imposing liability by reason of an EU liability, an EU obligation, and where neither the content of the regulations nor the explanatory materials suggest any intention to do more as to remedies than to mirror the obligations of the United Kingdom. In addition, we point out that the regulations provide for a remedies regime which is very distinct from that which applies to an ordinary domestic claim for breach of statutory duty. There are very peculiar features of this regime, understandably so, which take it out of the ordinary. First of all, and the court has seen all of these, first of all, there's the automatic suspension of entry into the contract when the defendant is notified during the standstill period that proceedings have been issued. That was Regulation 47G. Secondly, there is the setting aside of the contracting authority's decision to award a contract, which is normally a feature of public law proceedings, a judicial review. It's not a feature of private law claims for a breach of statutory duty, but that's what the court does in this context, 47I2A. And thirdly, as the court saw, there's even the power in the court in defined circumstances to award financial penalties which are paid into the consolidated fund. That's Regulation 47J 2B. So far from suggesting that the claim here under the regulations has the characteristics of a standard English law claim for breach of statutory duty, I say that the scheme under the regulations shows that the claim has a distinct character. That's all very far from surprising, given that the intention of the regulations is to implement the EU obligation, and the EU obligation is a form of state public law liability being imposed distinct from private law.
Yep.
As I recall it, there is a provision which I don't think has been taken up in the UK regulations, empowering member states to confine a right to damages to cases where the contract is set aside.
Yes, indeed.
Is that relevant to the point that you're presently making? It would effectively mean that an unsuccessful bidder who did not succeed or didn't perhaps try to get the decision set aside would have no right to damages either.
I mean, your lordship's referring to Article 2.6
Yes.
of the original of the remedies.
That I
Directive.
imagine is primarily relevant to a point you haven't yet come to, but I wonder whether it's relevant in this context also.
It's, as your lordship says, it's not an option that the domestic system has taken up. But again, what it demonstrates is that this regime is not equivalent to a standard private law claim for damages. It's a unique system that is designed to recognise the particular characteristics of public procurement as recognised by the domestic law power to set aside, to prevent the contract being entered into during the standstill period, the power in private law proceedings to set aside the contracting authority's decision, the power to impose financial penalties. All of these features, and the one that my lord refers to, suggests that this is sui generis, and to say it is a claim for breach of statutory duty in tort really doesn't do justice to the nature of the legal proceedings that are here concerned. And in any event, we add with great respect that His Lordship Lord Justice Voss was wrong to assume, as he did at paragraph 67 of the judgment, that it is inconsistent with a claim for breach of statutory duty to require that the claimant must satisfy a sufficiently serious criterion before damages are awarded. And the reason I say that is that a factor-tame claim for damages against the state has been recognised in domestic law as a claim for breach of statutory duty. It's a claim for a breach under Section 2.1 of the European Communities Act. And that was the view taken by the domestic courts in the factor-tame litigation. I take your lordships to Volume 4, tab 49, which is the divisional court judgment in factor-tame. It's page 1961.
Yeah.
It's a divisional court composed of Lord Justice Hobhouse, Mr. Justice Collins and Mr. Justice Moses, an interesting composition of the court. And they addressed this question at paragraph 173, which is page 2009.
Thank you. Yes.
Paragraph 173.
Thank you.
They say, in community law, the liability of the state for a breach of community law is described as non-contractual. In English law, there has been some debate as to the correct nature of the liability for a breach of community law. In our judgment, it is best understood as a breach of statutory duty, and the statute is the European Communities Act. At 174, and they give some authority for that.
Yeah.
And at 174, thus, whilst it can be said that the cause of action is sui generis, it is of the character of a breach of statutory duty. And of course, in factor-tame, that claim for breach of statutory duty is a claim for damages that can only succeed if the factor-tame criteria are satisfied, in particular sufficiently serious.
Why did it matter in this case what the characterisation would be if the origin of the rule was UK law? Which effectively is what.
Well, I'm not sure it did matter, but nevertheless, the divisional court thought that in order to address the question, which was the very real question in fact to tame, can the claimants, whose argument was that the fishing requirements had not been respected by the United Kingdom, they were suing in the domestic court for a remedy of, well, an injunction and also damages, they had to identify a cause of action. And there was, of course, the constitutional issues, was the Merchant Shipping Act subject to the requirements of community law. And the divisional court recognised it was necessary to identify the nature of the cause of action. And that analysis...
Was whether you could get exemplary damages.
That's what it was about.
Yes, exemplary. I'm grateful. Yes, exemplary damages were only awarded for breach of a statutory duty if the statute so provided, and the Communities Act did not so provide. That was 154 to 182. I'm very grateful to my friend. And that analysis, this was in the nature of a breach of statutory duty, was the view shared. It wasn't overturned in the Court of Appeal or in the appellate committee. So the point I make is that if factor-tame damages, being a claim in domestic law for breach of statutory duty, can be limited in circumstances or denied in circumstances where you cannot satisfy the sufficiently serious criterion, it is no answer to our contention that the sufficiently serious criterion applies under the regulations for Lord Justice Voss to say, well, this is a claim for breach of statutory duty.
In the case in the divisional court, which you mentioned, Secretary of State for Transport, the statutory duty could only be, since this appears to be an action for breach of a duty imposed by Article 86, effectively breach of the treaties as made part of your domestic law by the 1972 Act.
Yes, the statute.
Yes. So, I mean, it's inconceivable one would incorporate in that context more than Europe required, because the 1972 Act simply requires us to give effect to the treaties. Here we have regulations, but you say it'd be odd if a different result arrived, if suddenly the measure was different, simply because it had been by way of implementation of a directive rather than by incorporation of the treaties.
I'm simply making the point that to categorise the claim as a breach of statutory duty
doesn't help you.
Doesn't help you. Doesn't take the argument any further forward. The argument remains: was it the intention? Was it the intention of these regulations, read in context, read in the light of the explanatory materials and all the other material? Is it the intention to do more than impose in domestic law the obligations in community law, which are the factor-tame criteria, sea strikers, or was it the intention to do more than that?
Yep.
And to say it's a breach of statutory duty, in my respectful submission, substitutes a label for analysis. There's one other case that...
Otherwise, one would have to conclude that every breach of EU law, at least of an EU law that was intended to confer rights on the particular claimant, had all the ordinary incidents of a UK tort.
Yes, indeed.
That would be a fairly remarkable development.
Yes, it would. Well, particularly in the context of these regulations, which, as I've sought to identify, have very special characteristics. They're perfectly understandable in the light of the directive and the standstill provisions and all the rest of it, and the limits on the nature of the remedies. It is a very bespoke remedies regime under the domestic regulations because of the public procurement context and because of the nature of the directive.
Well, if one was talking about I go back. If one was talking about a cause of action for breach of the treaties, one would be distorting
Yes.
what the treaties meant, and
Precisely so.
simply because it happens to have here to come through a regulation,
Yes.
because we're talking of directives.
That's my submission. And the factor-tame approach is, in my submission, it's supported by many other cases. Just one more, Volume 5, tab 61. Your Lordships, your Ladyship will see the Phonograph Performance Limited case, page 2472.
Sorry, can you give me the flag and bump?
Yes, it's Volume 5, it's tab 61, page 2472. And it concerns the claimant's a licensing body, and it was claiming against the Crown, this is the head note, it's claiming against the Crown for a breach of EU obligations under a directive. The directive said that if a phonogram was published for commercial purposes or was broadcast, the performer, the producer, had a right to be paid a single equitable remuneration by the user. And there was a complaint about some restrictions that the domestic legislation provided. And at page 2478, Sir Andrew Morritt, Vice-Chancellor, at the top of page 2478, paragraph 11, he said at the outset it's necessary to consider the nature of the claim. He refers to Frankovich, Brasserie, Dupescher, and he refers to the criteria for damages. 12. The nature of such a claim in English law was considered by Lord Justice Hobhouse. In factor-tame, the Divisional Court concluded liability had been established. They went on to consider whether exemplary damages could and should be awarded. In that context, His Lordship considered liability was best understood as a breach of statutory duty. He relied on Garden Cottage, Bourgogne. Transposed to the facts of this case, the duty for the breach of which the Crown is sued is that imposed by the directive and Section 2.1 of the European Communities Act 1972. And that's our point. It can't matter whether or not the breach of statutory duty is under the 1972 Act or it is under a particular set of regulations. And we're not aware that it's ever been suggested until the present case that because the nature of the claim in domestic law in the context of an obligation under EU law-derived regulations is for a breach of statutory duty, therefore the criteria in factor-tame cannot apply. And therefore we submit in relation to this first preliminary issue, we invite the court to conclude that the factor-tame requirement that the breach must be sufficiently serious applies both under the directive and under these regulations.
Thank you.
The second of the preliminary issues I can deal with more briefly. The question, as I indicated, is whether it is open to a court to say that the disappointed bidder is not entitled to damages or is entitled to lower damages because it, the disappointed bidder, has unreasonably failed to use the standstill procedures to enable the merits of the complaint to be determined before the contract has been entered into. And the Court of Appeal said, no, that is not a claim that can be raised by the appellants, not a defence that can be raised. The Court of Appeal dealt with it at Appendix Part 1A, 197 to 197 to 199.
Thank you.
It's paragraphs 71 to 77. They call it the first preliminary issue. The order was different there. And essentially, what Lord Justice Voss said was that both under the directive and under the regulations, the disappointed bidder has a choice. And if it decides not to use the standstill procedures, not to go for the injunctive relief before the contract is entered into, that has no relevance to its right to claim damages if it can sustain its substantive complaint after the contract has been entered into.
Yep.
Our submission is that the Court of Justice in Luxembourg has emphasised the desirability of reviewing procurement decisions at a time when any error that has occurred can be put right, and that the award of damages is a secondary consideration.
Would you accept that, as a matter of purely English damages law, you'd never have an obligation to mitigate by, for example, rescinding a contract if that had been open to you, as opposed to claiming damages? They're simply alternative remedies.
I say that there are cases which I'm going to come to, particularly in the context of rectification of wills and other chancery procedures, where the court has accepted that the failure by the claimant to use some other remedy is a reason for denying its damages claim.
Right.
And I also...
That is a matter of... is your argument based on English law principles or on an implication into the directive of a mandatory requirement of this nature?
My claim is primarily based on the argument that under the directive, the failure to use the standstill procedures, as a matter of EU law, not under the wording of the directive, as a matter of EU law, the failure to use the standstill procedures unreasonably is relevant to your claim to damages. And if I'm right in the submissions that I have previously been advancing to the court this morning, that the regulations are merely intended to transpose the obligations under the directive, then the same conclusion follows. The regulations confer no greater entitlements on the claimant.
Understand.
But I think it's fair to say that the Court of Appeal's approach really stems from their decision that this was analogous to a common law claim.
Precisely so, my lord.
Therefore, you apply common law.
Precisely so. The Court of Appeal's approach, as your lordship rightly reminds me, is that these regulations are not simply implementing EU law, and therefore normal principles of tort law should apply. But
So it's the same point where it's breach of statutory duty.
It is.
On both points. Yeah. Okay.
It is, my lord. Can I deal first and briefly with community law, with EU law?
Yep.
The recitals to the original remedies directive are volume 7 of the materials.
Yep.
At tab number 82,
Thank you.
which is at page 3030.
Thank you.
And on the left-hand side of the column, left-hand side of the page, 3030, volume
Yep.
7, tab 82, it's the second whereas, the second recital. Whereas the existing arrangements, both national and community levels, for ensuring their application, that's the application of the substantive provisions, are not always adequate to ensure compliance with the relevant community provisions, particularly at a stage when infringements can be corrected. Now, this was looked at by the Court of Justice in the Alcatel case, and the Alcatel case is at volume 2, tab number 15, which is page number 1166. And the Austrian court was asking the Court of Justice whether the member state is obliged to allow the disappointed bidder to challenge the award of the contract before the contract is entered into. This is the origin of the standstill provisions.
Yep.
And the court deals with the matter first at 1198, where it identifies the question. Page 1198, it's paragraph 24, 1. When implementing the directive, are member states required by Article 2.6 to ensure that the contracting authority's decision prior to the conclusion of the contract as to the bidder in a tender procedure with which, in the light of the procedure's results, it will conclude the contract, i.e. the award decision, is in any event open to a procedure whereby an applicant may have that decision annulled if the relevant conditions are met, notwithstanding the possibility, once the contract has been concluded, of restricting the legal effects of the review procedure to an award of damages. And the problem was that in Austria you could sue for damages, but you couldn't stop the contract being entered into.
Right.
And the court dealt with this at paragraph 36,
Yep.
which is page 1202. 36, the relevant public body and the Austrian government contend essentially that the organisation of the procedure whereby once a contract has been concluded, the decision of a contracting authority may be challenged only insofar as the unlawful nature of the decision has resulted in damage to the party seeking review, and whereby the procedure is being limited to easing the conditions for the award of damages, complies with Article 2(6). And then I don't think I need to read 37, or perhaps I should. As the Advocate General observed, it's clear from the actual wording of Article 2(6) that the limitation of review procedures provided for therein applies only after the conclusion of the contract following the awarding decision. The directive thus draws a distinction between the stage prior to the conclusion of the contract, to which Article 2(1) applies, and the stage subsequent to its conclusion, in respect of which a state may, according to the second paragraph of Article 2(6), provide the powers of the body responsible for the review procedures are to be limited to awarding damages to any person harmed by an infringement. 38. Moreover, the interpretation proposed might lead to the systematic removal of the most important decision of the contracting authority. That is to say, the award of the contract from the purview of the measures which under the directive must be taken concerning the review procedures referred to in Article 1, thereby undermining the purpose of the directive, which, as noted, is to establish effective and rapid procedures to review unlawful decisions of the authority at a stage where infringements may still be rectified. And this is repeated at the end in paragraph 43. It follows that the combined provisions of the directive are to be interpreted as meaning that the member states are required to ensure that the contracting authority's decision prior to the conclusion of the contract as to the bidder in a tender procedure with which it will conclude the contract is in all cases open to review in a procedure where an applicant may have that decision set aside if the relevant conditions are met, notwithstanding the possibility, once the contract has been concluded, of obtaining an award of damages. So there must be this procedure.
On the face of it, that's creating an additional right rather than an alternative one.
That I'm coming on to. Certainly, I don't say that that of itself provides an answer to the point that we are seeking to raise, but it's a starting point because it shows that the Court of Justice regards this option of seeking to stop the contract coming into force as a very important feature of the remedies regime. And it led to the amendment of the remedies directive. Now, we add to that what was said by the Court of Justice in the Brasserie du Pêcheur and Factortame litigation. And can I take the court back to volume 1, tab 13, at page 1146. Actually, at page 1146 of volume 1, tab 13. And this is in the context of the damages claims. And at paragraph 81,
Yes.
the court says that the national courts are essentially asking the Court of Justice to identify the criteria for determination of the extent of the reparation due by the member state responsible for the breach. And at 84, the court says this: in particular, in order to determine the loss or damage for which reparation may be granted, the National Court may inquire whether the injured person showed reasonable diligence in order to avoid the loss or damage or limit its extent, and that's normal mitigation principles, and this is the point, and whether in particular he availed himself in time of all the legal remedies available to him. Indeed, says the court, it is a general principle common to the legal systems of the member states that the injured party must show reasonable diligence in limiting the extent of the loss or damage or risk having to bear the damage himself. We also rely on another judgment of the Court of Justice, which is the Dansk Slag Terrier case, a German case, which can be found at volume 2 at tab 17. This is in the context of animal health, directives on animal health.
Right.
It's volume 2, tab 17, it's page 1220.
Yep.
This one is a judgment of the Grand Chamber of the Court of Justice. And we draw attention in that judgment to page 1292, paragraph 58.
Thank you.
1292.
1292.
Almost at the end, yeah.
And we're looking at question 5 at the bottom of the page, paragraph 58, where the Grand Chamber says this. It says, by its fifth question, the referring court essentially asks whether community law precludes a rule such as that laid down by the local law, which provides that an individual cannot obtain reparation for loss or damage which he has willfully or negligently failed to avert by utilising a legal remedy. The referring court elaborates upon its question by asking whether such a national rule would be contrary to community law insofar as it were applied subject to the proviso that recourse to that remedy be reasonable for the person concerned. The referring court would like, finally, to ascertain whether recourse to a legal remedy may be regarded as reasonable when it's likely that a court would make a reference on the question. 59. As has been recalled when answering the previous questions, it is for the member states in the absence of community legislation to lay down the detailed procedural rules for legal proceedings intended to safeguard the rights which individuals derive, insofar as those rules observe the principles of equivalence and effectiveness. As regards utilisation of the available legal remedies, the court held in Brasserie de Pêcheur and Factatain, paragraph 84, that's what I've just shown the court, in relation to liability of a member state for breach of community law, that the national court may inquire whether the injured person showed reasonable diligence in order to avoid the loss or damage or limited extent, and in particular, whether he availed himself in time of all the legal remedies available to him. Indeed, it is a general principle common to the legal systems of member states. The injured party must show reasonable diligence in limiting the extent of the loss or damage or risk having to bear the loss or damage himself. It would be contrary to the principle of effectiveness to oblige injured parties to have recourse systematically to all the legal remedies available to them, even if that would give rise to excessive difficulties or could not reasonably be required of them. And then there's a reference to the Metal-Gesellschaft case. And at 64, consequently, it is to be concluded community law does not preclude the application of a national rule such as that laid down in national law, provided that utilisation of the legal remedy in question can reasonably be required of the injured parties for the referring court to determine in light of all the circumstances of the main proceedings whether that is so. So the case law, we say, establishes two principles. It establishes both in Brasserie du Pêcheur and in this Grand Chamber judgment of Dansk Slag Terrier that as a matter of community law, the general principle of damages is that the national court can deny damages where you have not availed yourself in time of all the legal remedies available to you, where it would be reasonable for you to use those legal
What it
remedies.
decided was that it was consistent with EU law for German law to have a rule which might require you to mitigate your loss by availing yourself of an alternative remedy. Now, if English law does not have a corresponding rule, that decision doesn't take you very far, does it?
Well, in my submission, it takes me this far. The general principle of EU law is that you can be denied your damages remedy if you have failed to use available legal remedies. That's the general, as a matter of EU law.
This authority, this authority simply says it's open to national law to do that.
Well, it says more than that with respect, because at paragraph 60, it is approving the principle stated in Brasserie du Pêcheur by the Chamber, by the court itself in Brasserie du Pêcheur, that as a matter of community law, you can be denied your damages remedy if you fail to use available remedies. And I say that's the principle.
Is that a community law principle in Brasserie du Pêcheur? I'm just going back to the paragraph you relied on, 84. That seems to be focused on the national court. And 83 says, in the absence of relevant community provisions, it's for the domestic legal system of each member state to set the criteria. I'm not sure it is saying it.
Well, the court...
I mean, it's also, since they say it's common to all legal systems, maybe it's also part of European law, but...
Well, it would be very surprising in my submission if you were suing for a breach of EU law if the Court of Justice did not apply in relation to EU law the principle that it set out at paragraph 84 of Brasserie du Pêcheur and at paragraph 60 of Dance Slag Terrier. That is, that just looking at the matter from the perspective of EU law, that you're not entitled to damages if you have unreasonably failed to use a remedy available to you. And it is true that the Court of Justice then says it's a matter for domestic law whether it applies that principle or it doesn't. But my submission is that in the context of the Remedies Directive, by reason of the recital, by reason of the judgment of the court in Alcatel, it is clear that the remedy, the standstill remedy, is regarded as of crucial importance. And I therefore submit that under the directive, if you fail unreasonably, it has to be unreasonably, but if you fail unreasonably to use that remedy, then the court is entitled to say you will be denied your claim in damages. And if that's right, the only question, important question, but the only remaining question is whether the domestic regulations were intended to say something different to that. And in my submission, there's absolutely no material to suggest that the regulations were intended to confer on the disappointed bidder a more generous approach to the question.
If you're wrong about that, do suggest that in this particular context, English law recognises any similar principle to the one you advance under EU law?
Well, as I indicated in answer to...
You said there's some authorities.
There are. Can I show you, Lordships, I've noticed the time. It's 1 minute to...
Just to be clear, I mean, on who does the onus lie? You say it's got to be unreasonable, so presumably you've got to plead that they were unreasonable in not pursuing those remedies in this case.
Yes, well, I anticipate the burden of proof is not going to be determinative in this case. I mean, our case is that the directive has created a standstill remedy that, provided that you say to the public body within the 10-day period, we object, they're not entitled to award the contract.
Yes.
It goes to court. The reality is that the court are going to ask for a cross-undertaking in damages.
No, I understand all that, but on the facts of this case, as I understand, we're in the position that the other side haven't explained why they didn't.
No, indeed.
On the other hand, I'm not sure whether you've asserted that they did so unreasonably.
Well, that will be our case. If I'm right in principle that a failure unreasonably to use the standstill remedy can adversely affect your right to damages, then this will have to be determined. But I'm not asking this court to make any finding. There's obviously would be a very real dispute between the parties as to...
Just a question of principle.
It is, yes. And their case, my friend's case, with which the Court of Appeal agreed, is that our contention, they failed to use the standstill remedy, and they did fail to use it, and they failed to use it unreasonably, which they dispute, is completely irrelevant, because this is a claim for damages.
So you were going to take us to a case.
Well, I am. It's 1 o'clock. I'm entirely in the court's hand.
I think you've got a couple of minutes still, according to our clock.
Oh, well, then
One thing that's reliable is that clock is always wrong.
Well, there's a
It's
couple
a bit unpredictable
of
how wrong it is, but anyway.
a couple of authorities.
Can I just, before you leave that point, I mean, do you accept that if the problem was that there was a ground of ineffectiveness, an award of damages would not be an alternative to the remedy of applying for a declaration of ineffectiveness? I mean, I'm looking at 47J, which specifically says that an award of damages may be made whether or not the court acts.
So 47J.
Yes.
Yes, in those terms, the court must, if satisfying the grounds of ineffectiveness applies.
Yes, but if you look at C, damages can be awarded regardless of whether the court also acts as described in A and B. So if
A and B are concerned with very limited...
Well, I understand that, but the argument that damages are an alternative remedy would not apply. You couldn't say it was an alternative to applying for a declaration of ineffectiveness. But your submission, I think, has got to be that the principle is fundamentally different, where it's not a case of ineffectiveness, but a case of breach.
Yes, but ineffectiveness concerns circumstances where the whole procedure...
The breach is much more fundamental.
I mean, the ineffectiveness in 47K is first, where you've awarded the contract without prior publication of a contract notice. Secondly, the contract has actually been entered into in breach of the standstill procedure.
I'm not suggesting that ineffectiveness has any relevance in itself to this case, but this is one context in which it's clear that an award of damages is not an alternative to some other remedy which is conferred by the directive.
No, I entirely accept that. I mean, the regulation has recognised that it's that once you have a contract, there are various remedies that you can confer, but 47J2 does not address a case where the standstill procedure was reasonably open to the contractor, and yet it has not used that procedure. That's the context that we are concerned with. And my case is that the directive is very clear on the importance of the standstill procedure. It's easy to understand why the standstill procedure is introduced, because it does provide a remedy at an earlier stage. It avoids the unhappy situation that my client is at risk of having to pay the person who carries out the work, and is having to pay vast sums in damages to the disappointed bidder as well. And the whole point of the standstill procedure is that it's much better, isn't it, in everybody's interests to sort out any complaint before the contract is entered into rather than after the contract is entered into. And therefore, if the respondent has unreasonably decided, well, we won't go for the standstill procedure because, for example, we don't want to give a cross-undertaking in damages, even though we're perfectly able to pay for it, then the court should have power to say, you've chosen not to use a remedy which any reasonable person would have used in those, that puts it rather high, which a reasonable person would have used in the circumstance. You've deliberately chosen not to use that procedure which would have sorted the problem out, and you wait, and then you claim damages. That's unreasonable. In my submission, that's contrary to the whole intention of the directive in this respect. And I do have some authorities, they're not in this area.
I think we'll probably control our impatience to see those authorities till after the short adjournment.
Thank you, my Lord.
Thank you very much, Lord Panic. We'll resume again at 2 o'clock.
Thank you.
Court's now adjourned.